Good afternoon, everyone. So we are going to start the event. So before we start, it is my moral duty to introduce our eminent speaker, Dr. Rama Prasad ji. So he is a distinguished academician and researcher in civil engineering with a strong focus on artificial intelligence, machine learning, and innovative construction technologies. He has made significant contribution through patents, research, publication, and advanced design methodology to integrate artificial intelligence into sustainable construction practices. With decades of academic and industrial expertise, Dr. Prasad has been actively involved in guiding students, researchers, and industry professionals in pioneering research on AI-driven design optimization, smart materials, structural monitoring, and automated construction processes. He has authored numerous research papers, textbooks, and patents in emerging areas of civil engineering and AI applications, strengthening the link between traditional engineering and next generation technologies. His vision includes creating global platforms such as Global Research Academy and initiatives like Association of Indian Civil Engineers to foster collaboration, knowledge exchange, and innovation. Through his leadership and dedication, Dr. Rama Prasad ji continues to play a pivotal role in shaping the future of civil engineering education, research, and industry transformation. So, with this small introduction of the speaker, now I would like to invite himself to start with his discussion.
Yes, sir. Yeah. Thank you so
Over
much,
to
sir.
you.
Thank you, Sumit Gandhi, sir, for inviting me for this webinar on intellectual property rights. Thanks a lot, sir, for your brief intro about me. Now I will share the screenshot. Just sharing, sir. Hold on. Okay, sir. Is it visible, sir?
Yes, yes, it is visible, sir.
Yes, sir. Yeah. Yeah. First of all, I want to say thanks to the head of the department, Sumit Gandhi, sir, for inviting me for this webinar on intellectual property rights in JP University of Engineering and Technology, Guna. Coming to the patents, first intellectual property rights, first we must know what is a property. So before coming to the intellectual property, the first thing is under the property, we have a tangible as well as intangible. You know, if you take example of movable cars, there is a car, immovable, there is a building. These are comes under the tangible. But if you look into the property, intellectual property, it comes under the intangible things. So in the intangible, under the intellectual property rights, we have different things like copyrights, geographical indication, trademarks, utility patents, and design patents. These are the things we are going to discuss in this presentation. Yeah, these are the things, for suppose if you look into the patent, it should be exclusive rights given to the person over the creation of their minds for the certain periods of time. That means there should be legal rights and intangible potential assets and a monopoly. That means if you look into the patents means it comes under your invention. Is any department, whether it is a science or social background or a computer science or civil engineering, electrical, electronics, life sciences or agriculture, whatever it may be, if there will be a invention or if you are making you make some invention of the material or composition or any product, or if there is a solution, technical solution for the technical problem, for these all things comes under the patents. Again, if you go to the industrial designs, that means only it is a shape of your invention. The trademark means that is a symbol or the company logo that comes under the trademark. And copyright means where the literature or artistry, literacy, dramatic creations, these are all comes under the copyrights. And geographical indication, this is all, if you look into that statewide or area wise, we have a special things are there that comes under the geographical indications. I will tell you the examples clearly. Yeah, if you look into the organization chart of this patents, the Ministry of Commerce and Industry, Department of Industrial Policy and Promotion. Under this, we have a Controller General of Patents, Design and Trademarks. For Patent Office, we have four offices are there. Those are Kolkata, Delhi, Mumbai, Chennai. Trademark is separate. Geographical is available only in the Chennai, and patent information in the Nagpur we have available. Yeah. Come, what is the validity? For suppose people are nowadays, once they file the patents, after that there is a procedure like publication of the patent as well as the FER, first examination reply, and before filing the patent, while doing the provisional filing of patent, at the time we have to do pre-art search. But that is all the secondary part. But here in my slide, what I am showing, the exactly common man, what he must know, what is the validity, maximum protection of your patent. After that, it will be a public property. For suppose if you look into the patent, it is 20 years, but every year you have to do renewal for that one. This act is comes under the 1970. It is amendment mark. The trademarks, the maximum protection is the lifelong protection. But after 10 years, we have to do the renewal. These trademarks act comes under the 1999. It was amended in the 2010. In the coming to the design products, the design means the maximum protection of the design is generally it is 15 years only, but after 10 years we have to do renewal for the next 5 years. This act is comes under the Design Act 2000, and it was amended in the 2014. Coming to the copyright is having the maximum protection is 60 years, but there is no need of renewal for this copyright. This copyright is happened in 1957, and it was amended in 2012. The geographical indication, it is also lifelong, but after every 10 years we have to do the renewal. That for suppose sometimes patent will cease and be transferred to the public domain if patents are not renewed within the 6 months of expiry of concerned year by paying the renewal fees. This is the chart. You see the relation between the intellectual properties as we discussed, patents, copyrights and trademarks, all the things. If you take an example of Coca-Cola, okay, this design, if you see, the logo of that Coca-Cola comes under the trademark. Whatever the logo is showing on the table, that comes under the trademark. The shape of the bottle comes under the industrial design. The patent, with respect to the bottling equipment, that one we can get the patent. And the copyright means whatever the text database we are using in the website, that all comes under the copyright. If you look into a single product can be protected in the more than one IPR. The product is, the Coca-Cola is a product, but the intellectual property comes patent, copyright, as well as trademark. These three are coming under uh, this this Coca-Cola product. Next, introduction to the IPR. Yeah, the IPR in this, if you look into the fan, and here I shown a Apple phone and Kolhapur chappals. If you see the Kolhapur chappal or Tirupati Laddu, the Balaji temple in Tirupati in Andhra Pradesh, this comes under the geographical indication. But the logo, if you see iPhone, the Apple logo is that comes under the trademark. These are the some the design part. These are the patent rules. And what is the criteria for suppose patent act and rules? What are the first criteria is novelty. Obviously, without novelty, we can't do anything. That is the first and foremost things. But one thing, sometimes which are non-inventions also, as frivolous or obvious, injurious to the public health, mere arrangement or rearrangement, discovery of scientific principle, discovery of living thing or non-living thing substance in nature, method of agriculture or horticulture, a mathematical or business method or computer program. These are all non-patentable. Okay, for suppose if you see. Different types of the things, industrial designs, these are the industrial designs we will get. And trademark, it is a brand or logo. These are the examples of brands or logo like Yahoo, Adidas, BBC and BMW, CNN. These are all comes under the trademarks. The copyright, the life of author, as we discussed, it is a 60 years, but after that we can renewal also. And sometimes USA, Europe, it is 70 years. Geographical indications, as we discussed, these are the geographical indications like basmati rice, Darjeeling tea, Kanchipuram silk saree, Alfonso mango, Nagpur orange, Kolhapuri chappals, Bikniri Buzia, Agrapet. So these are all comes under the geographical indication as a special based on the regional things. These are the website, but now the website recently last 5 days back they changed the new website. This is the website where you can see the right side the patent, designs, trademark, GI and all, where you can see the comprehensive e-filing as well as the public search, dynamic utilities, and left side you can see the journals. So these are all you can find out if you click on the public search. You see there is a public search under this. Whatever you want, either patents or trademarks, you can search here. Just simply by giving your application number here, you can by entering the captcha and you can get your application status. And this is the patent search also based on your date and also month, the logical operator, whether it is a granted or published. Based on this also you can search. And this is the design one. There is a small difference between the utility patent as well as design patent. And this is the trademark registry. And also these are the general ones. After filing form 1 and form 2, we can get the publication. Here you can see the patent journal. So like this it will show on every Friday the patent was publishing in the patent office different parts. This is the example of your patent. This one, for suppose if we see here, that is the application number is there, date of filing is there, date of publication is there, and your title of invention is there, and name of the applicant as well as the name of the applicant, name of the inventor. Both should be different or sometimes both should be same. And here the number of pages and number of claims are also important. Yeah, there are some disputes are going on nowadays. If you see the material life in pharma companies or construction companies, the major part of the disputes are going on. Why? Because after filing your patent, the invention, someone other people also they will file and they have some setups. So maybe before you are appearing into this, they will tell us how we already filed in a different country that comes under the PCT. Yeah, the typical parts of the patent application, as you know, the basic patentee, as you want to file a patent, these are the 9 things you must do, like your title, your field of invention, background of invention, summary of the invention, detailed description, drawings, abstract, claims. All things it should be there in your patent. The for startup companies where a lot of students are engineering students or science students, nowadays they want to do a startup. So what happened now in the, if you go to the make in India campaign, you in that website you can see all the sorts of intellectual property rights. The startup SIPP is there, Startup Intellectual Property Protection. It was launched in 2016 already itself, 80% compared to the other companies. Where if your startup is again, if it is registered under the DIPP, have obtained the certificate of registration, whenever you are filing the patent, you can get up to 80% of the remuneration or fee waiver. You can see the advantages of the startups. You can fast tracking of the patent or trademark application, availability of the facilitator for the patents, facilitator for the trademarks are separately. No need to pay a professional fee or the professional pay taxes. These are the things for the all the startups. And coming to these farms, like Form 1 application for grant of patent. Form 2 is a provisional or complete specification. Form 3 is statement undertaking and Form 5 declaration as a inventorship. And Form 26 is the authorization. And Form 18 request for examination. This is the most important. Form 1 and Form 2, Form 18. These three are utmost priority. And Form 9 also a request for early publication. Form 28 small entity or startup. While preparing a patent, first we know the application of the grant of the patent. In that means every applicant should be there in the Form 1. And Form 2 is regarding whatever we discussed the Form 2 provisional and complete specifications. For that one, if you want to get the early publication, we have to do Form 9. That is the request for the early publication. So after that, what happens? It is published. Once it was published, you have to go for the request for examination, Form 18. And one more thing is that if you are an individual person or patent agent, or if you are an institute or company, so based on the startup or small entity, you have to upload a Form 28 also. Based on that, you will avail fee waiver. These are the important things keep in your mind. The general procedure obtaining first, as usual, filing of a patent. First thing is that if you do for the Form 9 early publication, you will get within 45 days. Otherwise, your publication is after 18 months only. Once the pre-grant opposition or representation by any person, there will be a request for examination. Once the examination is a grant or refusal will be there. After that, publication of the grant of the patent will be happen. Once the post-grant opposition to grant of the patent also will be there. So then there will be a disposal that is taken by the decision by the controller of the general. Fee rebates also, as we discussed earlier. These are the things for the fees. For the one patent, natural person is 600, or others it is 8,000. Early publication is 2,500 only generally. For others it is 12,500. They are all natural person or startups. This is the rate. But if it is others, it is the cost is more. If it is a big companies, private limited companies and all. Request for examination is 4,000. Request for expedited examination is 8,000. Hearing opportunities every time. Whenever you get the hearing opportunity, you have to pay again 1,500. Amendment, if there is any change, you have to pay again 800 rupees. Amendment after the grant, you have to see 600 rupees. These are the forms as we discussed. If you look into the National Intellectual Property Awards, where you can see the Indian individual for the patents, Indian individual for designs, Indian individual for trademarks, Indian academic institution for the patents, R&D institutions or organization for patents, public-private limited companies for patents. That is a separate. Why? Because the cost also is so high in the public and private companies when you compare with the natural person or startups. And sometimes an MSME and startups are separate. Indian company registration and Indian company for creating brand. These are all comes awards. Now, I look into the reports, the annual reports by the government of India. You can see in 2019-20 we filed around in the patents 56,297. But compared to 2023, that is 92,000. That means almost 30 to 40,000 interest in the designs also. In 1920 it is 1,400, but is it 23-24 within a span of 5 years it was doubled. Same trademark also, geographical indications also, while in 1920 it is 42, but here 23-24 it is 134. These are all the statistical data. You can see the exact numbers here, and also these are the trademarks. So everything doubled. Geographical indications, copyrights. These are all the statewide filing of the patent application in the things. First it was Tamil Nadu, Maharashtra, Karnataka, Uttar Pradesh also is more, Punjab, Telangana, Gujarat, Andhra Pradesh, Delhi. These are all the things. The Madhya Pradesh, or the middle is there around 726. If you look into this, Tamil Nadu is filing 9,565, but Madhya Pradesh is filing 726. That means where the lagging is there, still researchers has to work more on these patents and all other things. This is a 23-24 data. Where if you see northeast states are very less, Sikkim, Leh Ladakh, Andaman Nicobar, Mizoram, Manipur, Tripura, Meghalaya, Nagaland, these all are below 100 only. Even Goa also having 43 because of so many industries or education institutions are very less. That's why maybe it is very low. But coming to the Chhattisgarh, Jharkhand, Chandigarh, Madhya Pradesh, West Bengal, Haryana, Uttarakhand, these are up to nearer to the 1,000. So Rajasthan, Delhi, Andhra Pradesh, Gujarat, Telangana are around 2,000 will be there. But where you can see the Punjab, Uttar Pradesh, Karnataka, Maharashtra, Tamil Nadu is from big jump is there, 2,000 to 10,000 are there. These are the designs based on the different states where people are doing the design patents. But here, if you look into this, the Madhya Pradesh is also at the time the middle only. Yeah. They are the top 10 country regional wise applications from different countries. Foreign applications they can file in our country by using the PCT. From PCT from different countries are they are filing. Like UK, they are for total 3,853 is there. But Germany, China, USA. Why? Because these are more means they want to establish their companies in India. So before that, they are taking the patents here through PCT. This is the revenue. These are the applications state-wise. If you look into this once, please check all the things, the trademarks, how they are filing in the state-wise. These are the number of trademarks, same like this. The March 2024 data. These are some data where we can see the methodology and novelty by diagram. We have to, for the design patents, we have to give the 6 views so that we can get easily. We have to do invention steps, claims. The claims are most important. How many claims are taking, as well as these are the example of UK patent, where you can see same abstract, objective, prior art development, what is the novelty is available, and each and everything we can shown here. Just due to time being, I am showing all the things. This one already I shown. And this is a certificate of UK design, and this certificate is a design IoT based smart construction robot design certificate. This is the Birla Institute of Technology and St. Bits Pilani campus, where they can got method and apparatus for the determination of the absorption characteristics of the concrete. Where we can see this is a patent, which is very difficult. They filed in 2018, but they got in 2023. That means 5 years. It is what happened to get the patent grant. These are some case studies. And where, if you look into this diagram, India, as per the Indian Patent Act, the procedure is common, like filing and the grant, and in between there will be a publication and examination will be there. And the legal representation or deceased, if it is a true or first inventor or assignee, they can file. Sometimes, non-patentable, like scientific principle or against natural or atomic energy, we can't go for the patent on these topics. But there will be a novel and application or inventive, we can go for the invention. Where we have to file, you can do with the e-filing as well as the patent office, you can file. And this is the invention, where you can see this diagram. Once you got the invention, first you will see the novelty check and the patentability. Once it is there, based on that, drafting a patent, and then filing of application, and application of the examination, and the grant of the patent. Yes, thank you, sir. For this I am ending, as if we talk on, it's a lengthy process. We can talk more and more, but now it should be a discussion part, so that we can get good connections. Sumit Gandhi, sir.
Yes, sir. Thank you, sir, for a nice presentation.
Yes, sir.
Now I would like to invite uh, to have some queries from the audience. Anybody have any queries, you can please ask.
Yes, I request the participant please ask the questions, or you can post in the chat box also. Santosh Bobade, sir. Any questions?
Okay, sir. Sir, let the audience to think about their queries. In the meantime, I would like to ask one thing. Is there, I'm audible, sir?
Yes, sir. Yes, sir. Audible. Tell me, sir.
I would like to ask, is there any emerging issues related with the AI are developing day by day? So, is there any issue regarding the AI and the authorship? Because many of the authors are continuously using the AI facility for writing the research paper or any such kind of related work. So, what are the emerging issues of AI in filing the
Yes,
patent?
yes, sir. Yes, the thing is, sir, while using the AI, even we can get only up to filing and publication. But after that, what happened, once if you go for the FER, first examination report, the AI content, it's not possible. Why? Because the hearing, it is not possible to show AI, the fake data. We have to show the product clearly. Based on that only, we can get the grant. Otherwise, it's not possible by using the AI, sir. It's highly impossible. Why? Because we have to show the clear product to the controller. Then only we will get. Not like drawings is highly impossible, sir. Yeah, the emerging technology day to day is increasing, but it's very difficult without a product to get the by starting the manufacturing industry. That is the biggest issue is going on still. Yeah, good question, sir.
Yes.
Some
Then, sir,
people they may asked in the why patents in nuclear domain is restricted. Yeah, that is all intellectual property of the government is involved. So that if after 20 years it should be a public. That's why they don't go for the all government secrets and all other things. Sumi sir.
yes, sir. Any other question from the audience?
Okay, sir.
Sir, one more question from my side.
Yes, yes. Tell me, sir.
What are the most common mistakes, that lead to the valuation reduction of the IPR filing?
Yeah, the most of the people, sir, what they will do, initially they will file a complete specification, sir. We can't do a complete specification initially. First, you have to do a provision certificate. Why? Because whenever you are writing your invention, once your lab work is going on, you have to concentrate on the claims. You know, the claims plays a major role. So the problem is most of the people, what happens initially they will go with the one or two claims. Later, what happens? They will add two or three, four, five. They keep on changing. So that is the big mistake most of the people doing in the filing of the patent, sir.
Okay, okay.
Yes, sir.
And
That's
and
why the invention background of your invention is utmost priority. Your claims are in priority, and where the applicability also is important, sir.
one
And
more
you
thing.
have to prepare a physical product like a prototype. You have to create. Without that, it's very difficult to get the utility patent grant.
Okay.
Hmm.
So, what is your suggestion? One more kind of query that what is your suggestion for the researcher? Uh,
Yeah, the researchers is for suppose if you are whatever the small invention, first you go with the prior art search. So prior art search means where you can get all your related data. In the prior art search, if your eligibility of getting patent, we can get before only. Based on that, we can do. And one more thing for utility patent grant, you don't publish a paper. If you publish any research paper, you can't get a utility patent on the same topic. That is the biggest mistake any researcher is doing. That is the
yes,
biggest problem. If they want clear literature, one more question they ask: literature review is not enough. Literature review is only enough for filing and publication. You never ever get the grant for literature. That is the biggest mistake all the research scholars doing in the entire India. They are simply to get PhD. They are simply publishing their papers. Once the papers are published on your same topic, it's highly impossible. The controller general will not accept that invention.
yeah, that is the same thing I would like to know. What you
Yes, sir.
have told just now. Yes, thank you, thank you.
Yes, sir.
Yes, any other question from any other participant from student side or from faculty side? I think, sir, there is no more question. So I would like to thank you for your presence and giving us your valuable time for taking this important session for us.
Yes, sir.
Right,
Yes,
sir. Thank you, sir. We will continue with you in the future also if we feel there
yes, sir.
is some
Definitely,
requirement.
definitely, sir. In the future, any physical event also you invite me, sir. I will come to any conference or any good workshops. We will deliver lecture on R&D, research, scope of journals and all other things.
Sure, sir. But what is, sir, you have any query? Sir,
Sir,
unmute yourself. Sir, first unmute yourself.
Dr. Siva, I joined very late actually, so I had no idea what was going on. Extremely sorry for that.
yes. Thank you, sir.
All right.
Okay, thank you, sir.
Okay.
Thank you,
Sir, I
thank
am
you, sir.
quitting, sir. Huh?
Sorry.
So I am signing off, sir. The
Yeah,
next
yeah,
time we
thank
will
you.
meet in your
Yes,
campus physically.
yes, yes. We'll invite you, sir. We'll plan
Yes.
some event and then we'll call you, sir. So,
Yes,
definitely.
sir. Yes. Thank you, sir. Thanks
Thank
a
you.
lot.
Thank
Thank
you.
you.
Thank you, the participant. Thank you all.